There's been for many years the perception that fashion law is something, a bit fluffy, a bit cute, not that serious. But in reality, it's about human rights, it's about employment, it's about protection, it's about asset, it's about giving so many communities, so many, entrepreneurs, really their bread and butter for living, allowing them to create assets that can be commercialized, giving employment to other people. And then really this is very important business. As a business that encompasses every sector of the economy, is probably the second, if not the first biggest industry in the world.
Welcome to the Page Points podcast from the WIPO Knowledge Center. My name is Anka and I will be today's host. Together, we will be diving into the world of fashion law with two remarkable experts, Irene Calboli and Eleonora Rosati. Together, they've co-authored the Handbook of Fashion Law, a comprehensive guide published by Oxford University Press that explores the intersection between intellectual property and the fashion industry. Let's tune in now to hear Irene and Eleonora discuss their handbook. Welcome to the podcast, Irene and Eleonora.
Hello, Anka, and thank you to you and the WIPO Knowledge Center for having us here today.
Indeed, thanks so much. It's a pleasure and an honor. Looking forward to the discussion.
It is a great pleasure to have you both on our podcast. The introduction of your handbook is entitled The Rise and Consolidation of Fashion Law as a Field of Practice, Study, and Research. Can you please tell us more about the scope of fashion law as a field of practice and research? And most importantly, how does the handbook define fashion law, and what does fashion law mean to you in a broader sense?
Well, thank you for the question. As we mentioned in the introduction that you just highlighted, fashion is not a monolithic term. It encompasses several meanings. It can relate to aesthetics, social and cultural norms, trends, and of course, perhaps even more so, commercial interest. Both Eleonora and I am very proud to say that Italians, and fashion, it's somewhat embedded in Italian DNA, but it's certain that Italians are both culturally and commercially attached to fashion. It's also certain that fashion has become a very important field of practice and study in many countries today. Because we found that it was difficult to find a comprehensive resource in English, we decided to edit this book, which combines multiple perspectives from many authors, from many backgrounds. And I would like to hear what Eleonora thinks about.
Indeed, fashion law is something that has become somewhat of a trending topic, but does not exist as an area of the law in itself. So, as indeed Irene was hinting at, it is a combination of different areas of the law, which have in common the fact that they affect the fashion sector, and of course need also to be applied in a way that is mindful of the peculiarities of the fashion sector. So I think that the main strength of our handbook is to bring together all these different legal perspectives, ranging from intellectual property to contract law, regulatory matters, data protection, e-commerce aspects, as well as frontier technologies, and have chapters that are authored by practitioners and scholars from different jurisdictions. So it is a way to try and find a unified lens through which all these multifaceted dimensions of fashion and the legal implications thereof can be studied and indeed understood.
Excellent. Well, if you agree, Eleonora and Irene, I'd like to frame our conversation into two parts. The first part, I would like to discuss what elements were covered in your book, drawing the reader's attention to the specific legal challenges the fashion sector is facing and its related solutions. And in the second part, I would like to discuss the future of the fashion industry and the legal challenges facing technological developments applied to the fashion sector. How about we begin by demystifying your outline? Tell us about the four thematic areas covered in your book and who is the target audience.
Thank you so much, Anka. Let me start by noting the foreword to our handbook was authored by Mr. Maciej Spunar, who is the first Advocate General at the Court of Justice of the European Union. Not only is this a great honor to have someone like him endorsing our book, but I think it's also testimony of the recognized importance of this emerging field of study, research, and practice. And we hope that there will be something for everyone to read, enjoy, and learn in the various chapters of this handbook.
Thank you very much. Well, actually, during the winter holidays, I had the chance to travel around the world with my own copy of the Handbook of Fashion Law. And I was impressed by the wide range of topics covered in the 41 chapters of the handbook, from IP law, like you've mentioned, contracts, and the interplay between emerging technologies and the fashion sector. I noticed that 55 professionals from diverse backgrounds, such as academia, the private sector, in house counsel, and international organizations, contributed to your handbook, which is, I think, absolutely remarkable. Can you please tell us more about the process of developing your handbook? How were the topics selected, and what gap in the existing literature on fashion law does the handbook aim to fill?
Well, as you mentioned, 55 professional is in fact a remarkable success, and we are very proud, but we're also most very grateful to our colleagues to have given their time, their expertise to be part of this great project. To put together a handbook of this size and depth really requires the cooperation of many minds. I want to give a lot of the credit for the creation of this book to my co-editor. I really want to say Eleonora has been the heart and soul of this project in many ways. The book really is groundbreaking in bringing the technology side, but also it really updates and combines together a lot of the IP and contract and general, perhaps previous literature on fashion. Another area that we're really pioneering is the green and sustainable and how that intersect with all the other contract, IP, and technology as it affects to fashion today.
Indeed, thank you so much, Irene. And of course, this project would have not been possible without you, because when I look from the outside, you have a finished book. But indeed, the work that goes into putting together the project and bringing in the people, and indeed also editing the various contributions, is quite substantial. So we hope that the readers will enjoy it. What I think makes the handbook stand apart from what was already available in the market is the fact that this is a book for those with an interest in fashion and the law, but is aimed at people already with quite developed legal expertise. So the books that were available, the articles that were available before the handbook, were mostly aimed at designers, people without a legal background. So, of course, the approach was also different. We hope that our handbook makes a difference and is a very helpful companion to those working in law, whether it is an in-house role, private practice, academia, students at either the undergraduate, postgraduate, or research level. So anyone who is in law and wants to transition to a fashion expertise, who is already advising fashion clients. And that, I think, is a strength that derives from the fact that many of the authors that we have involved work in fashion, whether it is in-house or in private practice. And then we also have academics that have been specializing in various aspects of the law that connects to fashion for several years. So I hope that in the end, the book will be appreciated by the target readership that we would like indeed to benefit with our work.
Do you have any recommendations on staying informed about the legal and technological changes that affect the fashion industry? Also, If you could give one piece of advice to aspiring designers, what would it be? Aspiring fashion lawyers as well.
Okay, so thank you for this question. So first of all, on how to stay up to date with relevant developments, I think that one needs to be on the internet. So read the relevant blogs, newspapers. There are many dedicated resources to fashion law, but at the same time, not to have a tunnel vision. Do not read only things that mention fashion and not care about anything else. And this leads me to my advice to those who want to work in fashion law. I have several people approaching me saying, how can I become a fashion lawyer? The thing is, you cannot be a fashion lawyer if you don't have a general understanding of the area of the law where you want to practice this fashion law. So you cannot be a contract lawyer in fashion if you don't know general contract law. You cannot be an employment lawyer in fashion if you don't know employment law. And you cannot be a fashion lawyer in IP if you don't have a basic understanding of trademark law, copyright law, etc., etc. So my advice is to students and wannabe fashion lawyers, be as broad as possible in your reading and in your research, because that is the only way for you to be a real fashion lawyer, someone that combines real practical expertise with knowledge of the fashion sector. So avoid skim through only to things that mention the word fashion, because that is not the way to go. So sounds harsh, but I think it's very important.
Yes, I could not agree more. Fashion, as we mentioned, is really a puzzle of many other disciplines. And fashion law in itself, unless we have a boutique law firm that has fashion clients, and so we can serve them in all the various legal aspects relating to their business and to their industry. But my advice is also to, particularly to fashion lawyers, it's get really your hands on some deep practice on contract, IT, IP, and then you can make a very good transition. Because otherwise, you don't have the background expertise that can actually make you be a more effective lawyer in the fashion industry. And this is the best way, perhaps, then later to go to work for, in-house. But even in-house, you need to know the various law well to be able to work with your various correspondent and your various law firms that might help you manage all your rights.
Thank you very much. This is great advice about the reality of the practice of law and how we can link it in the future with fashion law as well. Is there anything else you want to share with our audience about your handbook and what you hope readers take away from it? Also, what would you like our listeners to remember from this conversation?
Well, we hope genuinely that our handbook can be of use and useful to many in the industry, many lawyers, many students. You really want it to be used by, both of us teach fashion law and both of us will adopt it, but also many of our colleagues hopefully find it useful in their teaching, in the practice. And this is something that we really hope to have created a resource that can help our colleagues, our students to become better expert, and then to be more passionate and more inquisitive about the topics in general. Perhaps it's a bit cliche with some reference to one of the very best ever fashion movie, which is The Devils Wear Prada, and the very famous almost monologue by Meryl Streep mentioning why the color turquoise was absolutely crucial and important in an example of how the fashion industry is life for millions and millions. We can never underestimate fashion law. Both Eleonora and I are very, very serious professors in very, very serious institutions. And, there's been for many years the perception that fashion law is something, a bit fluffy, a bit cute, not that serious. But in reality, it's about human rights, it's about employment, it's about protection, it's about asset, it's about giving so many communities, so many, entrepreneurs, really their bread and butter for living, allowing them to create assets that can be commercialized, giving employment to other people. And then really this is very important business. As a business that encompasses every sector of the economy is probably the second, if not the first biggest industry in the world. And so to have more knowledge of fashion, it's not something nice to have, perhaps, but it's something very important for many, many lawyers if they want to have a better understanding of our society and how legal practice in general work. We can teach all sorts of laws using case law from fashion examples. And I think, there is a very important depth and a human quality and nature to a lot of these examples that goes a long way. So we really hope that this book helps people to put in context the importance. Of course, it's more fun to perhaps work in fashion than other areas, but it's equally, if not more serious and more important. So that's also something that we hope people can take away from it.
I will just echo what Irene has said, and I will note that our handbook is, I think, some form of achievement, but is also a starting point. And we hope that it can also serve readers to find not only answers, but also new connections and thoughts that will go to develop themselves. So we hope that we are sowing some seeds towards a better understanding of fashion law and accompanying our readers towards their professional development, answers that they are seeking, and research that they are doing.
Well, I can say as an IP lawyer myself, the handbook was definitely very useful for me. As you know, I work here at WIPO as part of the Office of the Deputy Director General for Copyright and Creative Industries on a wide range of creative industries, of which the fashion industry is one. I would like to know more if you can please tell us about how different intellectual property rights are used within the fashion industries.
Certainly. Of course, this is a very, very fast summary review. And to get, a very much longer answer, we encourage readers to actually consult the book. But intellectual property applies, I would say, in all its various different rights to the fashion industry. In fact, of course, probably one of the most intuitive rights is trademark, distinctive sign that identify products coming from a certain commercial origin. Trademarks today, not only the logos or the name of the product, but also the shape, the combination of color and shape, and so on. And that ties with creative industries, of course, in copyright, design applies to fashion, but also less commonly thought rights are very relevant in fashion law. Trade secret, patent, of course, depending on jurisdiction where we are, patent can be also design patent. I mentioned design, industrial design, design patent, but there is quite a lot of functionality that also goes into the protection of a variety of fashion items, and of course the machines and all the various infrastructure that is needed to produce these. One of the chapters that for me was very interesting to edit and to read also was the one about plant varieties. We might not think too much about the relationship between plants and agriculture and fashion, but both because a lot of fashion items are made by plants, just think cotton, but also because today a lot of the recyclable and eco-friendly fibers are actually made by reusing waste from the food industry, for example. There is quite a bit of increased interest in plant varieties relationship to fashion item. Geographical indication, of course, and I do a lot of work in developing countries and with a lot of textiles and the use of geographical indication for non-agricultural products. This is something becoming more and more relevant also in the European Union. So the whole spectrum of IP applies to fashion. Then, depending on the item that we are dealing with, whether it's a piece of textile, an accessories, a bag, a shoe, of course, a jacket, different rights can apply to that specific item. But in general, most rights apply to most items. And this is why it's also important to have both specialization, but sometimes for the IP lawyer to be able to step back and look at that item in context, because sometimes some protection like copyright, I think, is very, very important in the fashion industry. And perhaps underused compared to what it could be used by a lot of designers. And so to know more about IP on an interdisciplinary way is actually something that I think is very, very important. And we hope the book can offer support to lawyers and those who are interested in knowing more about the fashion protection through IP, the various IP rights can offer.
We can draw from our conversation that the intersection between fashion and intellectual property law is one of the core areas of fashion law. According to you, what are the most pressing IP challenges that the fashion industry is facing today?
Well, of course, as any industry, there is always a variety of challenges that affect the industry, and often the answer depends where in the industry the respondent can be. In the distribution side, in the production side, in the contract merchandising side, in the accessory industry, in the mass fashion industry, in the luxury industry, and so on. Our book touches upon many of these aspects. However, I think that one of the real challenge that the relationship between IP and fashion is facing today is this relationship between IP, fashion, sustainability, and a circular economy.
On my side, perhaps I will bring in a different perspective. And of course, my background is as an IP lawyer. And as I was mentioning in the previous response, one has the impression that there are so many IP rights that are potentially available. So you can get protection for pretty much anything. And that in principle is true. But in practice, it is challenging to obtain, for example, trademark registration of an unconventional sign, unless indeed you are able to produce evidence that in turn proves to be costly. And then this brings me to the additional consideration that I will make. Even though one accumulates all these rights, thinks that they have an unregistered design right, copyright, etc., I see real struggles at the level of enforcement. And that is true for any player in the industry, whether it is a small designer that thinks that they've been copied by a bigger brand, it is a David and Goliath kind of situation. It is difficult, if even conceivable, to bring an action for unauthorized copying against a bigger brand when you are a solo designer or a small company and so on. But also big brands face difficulties in enforcement. Today, we live not only in a fashion culture, but also in a dupe culture. But the truth remains that all these IP rights that one has secured or thinks that they have might be in reality difficult and lengthy to enforce, as well as very expensive. So I feel that the enforcement level is in need of some serious attention for all these rights to be meaningful also in practice.
You both talked about litigation, enforcement. This brings me to my next question. Can you tell us more about the significant differences in how fashion law is applied within the European Union compared to the US and Asia?
So I will start from the European dimension. So for copyright, now the jurisprudence of the Court of Justice of the European Union suggests that you cannot have requirements other than originality. But once again, what original means, I think, can be the subject of a discussion that goes on for days, if not weeks and months. It is an inherently ambiguous term, and what qualifies as original, I think, is a matter of debate and uncertainty. So there have been some players in the fashion industry that have been successful under this new standard of the Court of Justice, but there is also great resistance at the national level, at least in some EU member states, to accept that that is now the law, and in turn that the existing national statutes may be in need of repeal or substantial edits. Turning to trademarks, I would say that it is relatively straightforward to register conventional signs such as logos and words. But when it comes to less conventional signs, things are not easy at all. There has been case law also involving major players such as Dior, such as LVMH. They've tried to register their shape and pattern marks and they failed. So someone like LVMH is not able to provide convincing evidence. You can imagine how things might be challenging for smaller companies, smaller designs, and so on. And then, of course, there is the dimension of the other rights that we discussed earlier on, plant varieties, geographical indications. Now in Europe, there is the possibility also of getting protection, not only for agricultural GIs, but also for articraft and industrial GIs. And that might be something that will be used by, indeed, players in the fashion sector, broadly intended. But again, this is a very recent innovation, so time will tell.
Well, as you know, I divide my time between the United States and Asia, residing in Singapore and working quite extensively in the region. And, as a European, I actually like to see the comparison. So when we go to the United States, the tradition might have been that in the US, fashion law, it's not that important. But in reality, I would actually demystify this statement. I think there is, in terms of strong intellectual property protection, the United States has strong intellectual property protection that also apply to fashion items. When we look at the trademark registry, when we look at the copyright registry, because of course in the United States we have a register for copyright, even though there is no need to register, but of course to enforce right is better to register in terms of at least getting damages and attorney's fees. And at this point, in general, also as a right to sue, registration is relatively straightforward. But in the United States, there have been cases protecting fashion item related to enforcement. Of course, the United States might be stronger on exception and limitation, but what it seems to me is that the fashion industry thrive at this point in the United States. The United States is known to be one of the biggest market for luxury products, mid-level products, fast fashion as well. And I believe that the current system and the current level of rights seems to work very well. The United States has expanded copyright protection for fashion with the Supreme Court decision in Stare Athletica. In Asia, I think also the protection of fashion is more and more under the zoom lens of the courts, or certainly the IP offices. There is a lot of movement for small designers and even indigenous community to use a variety of rights, whether collective trademarks, certification marks, geographical indication of design rights. WIPO has done a lot of projects, for example, through the development sector, really helping communities, the copyright sector, creative industries as well. There are a lot of work done by technical assistance in that space, and I see more and more understanding, not only in developed Asian countries such as Japan, Korea, Singapore, but also developing countries that are very rich in tradition and fashion, for example, Indonesia, Batik, India, Malaysia, Vietnam, and so on. So there have been some interesting cases. Some, of course, are the multinational, the protection of the Louboutins, Red Soul, or some of the mega famous marks such as, again, LV or Hermes. But of course, there is quite a bit of national attention to designs as well from the regions. So that's very important.
Thank you very much to both of you. And I'm happy to hear, Irene, your feedback about what WIPO does. I would like to know more about the challenges that still exist in the cross-border enforcement of IP rights in the fashion sector.
Speaking of enforcement, of course, a big issue is the fact that IP rights are territorial. So you don't have a worldwide trademark, you don't have a worldwide registered design. So that means that also enforcement needs to proceed territorially. Of course, there have been experiences over the past few years in a way to reduce the relevance of territoriality. There have been indeed the courts not only ordering a pan-European relief in Europe, even for copyright, that in theory is still subject to 27 different laws, but also global relief. So I will say that territoriality is an issue for a global player. And then, of course, also the differences in terms of enforcement options and the damages that you can recover.
Thank you very much, Eleonora. We spoke about emerging designers, but also luxury groups. The handbook also covers the startup businesses and global successes in fashion. Can you share a few practical tips for emerging designers listening to us who want to protect their intellectual property?
Well, this is something very, very important for me. And I've been doing that again through some of the technical assistance in WIPO, particularly in Indonesia, Vietnam, and Myanmar, just in the recent times. So, what can small designers, and remember, intellectual property should not be and is not just for big fashion. It needs to be used more and more in a more effective way by independent designer, by small entrepreneurs, by SMEs. And this is really part of the reason why we hope this book cannot be useful just to lawyers defending, of course, big brands, but lawyers helping small designers. So, of course, for small designers, the most important thing is to understand that they need to be original. They need to create something that might be inspired by something else. But because, of course, innovation is always incremental, but they need to really invest in their own innovation in fashion. And then they need to be aware on how to protect. Of course, small designers might be more constrained by budget than big designer, but also big designer are very careful about budget, in my experience, as a former lawyer. So to understand what to use, when to use, unregistered right, register right, design right, unregistered design. I myself and Eleonora too teach to fashion designer. We not only teach lawyers, and so we actually really emphasize this basic, almost toolkit. And I know the creative industry sector is also done toolkits for designers, perhaps not specifically in fashion law, but that's something that they also could do for fashion designers. And to have this almost checklist of things can be really, really useful. Understanding that you have something valuable, you need to understand how to protect it. You cannot really do it yourself too much because you risk to do mistakes. You should not ever overextend your protection. You need to be careful about your budget, but you might want to think at the beginning of your journey. And so to have a bit of understanding of intellectual property, it's always very useful for fashion designers. So I'm all in favor of the activity that the WIPO is doing to try to reach out to communities all over the world to teach them a bit about the value of intellectual property. So the Director General, of course, had made that one of the primary mission of WIPO under his mandate, and I think this is very important for everyone, but certainly for designers.
I agree with you, Irene. Lawyers need to help independent designers, and at WIPO, we believe in IP for the good of everyone. So, changing gears a little bit, I would like to move on to global challenges connected to the fashion industry, such as sustainable fashion and the circular economy. Irene, I know that you are an expert in this subject, so my question goes to you. I would be happy to know more about how the book addresses the relationship between sustainability and intellectual property in the fashion industry. Also, how can IP law support eco friendly practices in the fashion industry?
This is such a new field that we don't really have high court decisions, but and probably the most interesting jurisdiction in this respect at this point is the United States, even though just recently we had some decision in Asia, for example, in Korea. But not all is tension and contention in the relationship between intellectual property and sustainability. In fact, certainly, and we have chapter relating to that as well, intellectual property can help. Of course, technology can help green development, trademark and certify products that are eco-friendly. Copyright can protect the originality of instructions and materials that relate to fashion and green technology. Of course, there is also the risk of greenwashing, and that's something that the European Union is taking very seriously now, with not one but two pieces of legislation related to green claims, the so-called green package. So I think this is really an area where the direction of looking for more eco-friendly practices is becoming a standard for the industry across the board, because the generation alpha and the new generation, the new shopper care. And it's driving a lot of these decisions. So I just look forward to see what's going to come next in this area.
I look forward to it as well. Thank you very much, Irene. As we talked about some of the topics covered in the first sections of the handbook, I would love to touch on my favorite part of the handbook, the fourth section, which I believe sets the tone for the current challenges that the fashion industry is facing regarding technology. In your view, what are the legal implications of emerging technologies such as 3D printing, the metaverse, AI, and NFTs on the fashion sector?
So let me start with artificial intelligence, since indeed there is no place where this is not the talk of the day. And of course, the fashion sector is no immune to that. And the AI is going to be used and is already being used in several different respects, both to anticipate consumers' spending decisions, and that is a case of predictive AI, but also to generate designs and also to enforce relevant rights. So the relationship between fashion and AI is going to be unavoidable. From a legal standpoint, of course, there are many questions that arise, starting from the possibility of using AI to create. How far can you push the use of AI without losing, indeed, your creative control and therefore ownership of the resulting design? There are questions of liability. What if you use a tool premised on AI that has been trained on materials that prove to be infringing of someone else's rights? Is this going to cause any risk for the fashion brand using these tools, whether it is to design, whether it is to anticipate consumer spending decisions, and so on? So I guess that from this perspective, it is clear that fashion, like any other sector, will need carefully to embrace AI. I think that this is a process that is somewhat unavoidable, but of course, the proper way to regulate AI, the relationship between different rights that are at stake in the AI debate, will be also necessary to address insofar as the fashion sector is concerned.
Related to 3D printing and NFTs, sometimes I wonder whether these are, in part at least, from a legal standpoint, two bubbles or two areas where, for example, in 3D printing, I remember maybe 10 years ago, there was a lot of discussion and fears when the technology started to become more available, whether that would become the avenue for people to 3D print their Hermes bag or their fake, luxury bags or luxury item at home. However, that's not happened. And on the other side, certainly 3D printing has revolutionized the industry in the manufacturing sector. NFTs, it's a very interesting question. We have seen some litigation in the trademark space, of course, with the very famous Meta Birkin case in the United States. This is probably in the fashion industry the biggest case, and now we know it's under appeal, so we don't know how it's going to conclude. So far, the court seemed to have sided with the fashion owner rather than artist, but it's certain that NFTs remain a very interesting tool. Blockchain, certainly, it's very important, and in the fashion industry has been increasingly used to certify authenticity of product and certify also authenticity of design as a potential private substitute, at least in some instances, to registration. I think our book does a really good job in addressing all of these issues in a very updated fashion.
I really liked how the fourth section of the handbook focuses on all these emerging technologies, the legal considerations. And talking about blockchain, Eleonora, I had the pleasure of working with you on the publication of an article on blockchain technology used to prevent counterfeiting within the fashion industry as part of the recently published edition on IP and fashion of the Journal of Intellectual Property Law and Practice of Oxford Academic, which you are the editor of. This brings me to my next question. What do you think are the challenges of counterfeiting in the digital age, and what technological tools can help fight against counterfeiting?
Thank you for this question, Anka, and thank you again for your contribution to the journal. So, as you point out in your own article, there are various technological tools that might help protect rights and therefore enhance the efficacy of enforcement options. But as these tools improve and emerge, so are counterfeiting methods. So indeed, it is always a game of mouse and cat, if you wish. So yes, there are new tools that emerge to protect rights, but also counterfeiters find a new way to infringe. So that is a bit the nature of this area of the law. And there are tools, like also Irene mentioned, blockchain, but also AI, that can be used effectively to protect rights.
Thank you very much. And speaking of all these emerging technologies, where do you see fashion law heading in the next decade, especially with the advancement in digital and global commerce? Are there any areas of research that your handbook identifies as unexplored or needing further research in fashion law?
Well, I think every area might need soon a second edition. The moment you finish a book, you realize, maybe we should have added this chapter. Maybe we should have added this other chapter. I think Eleonora and I went back and forth on we should add a chapter on that and maybe the other. And then eventually we got to 41 and the publisher said too many pages. Let's wait for the second edition. Certainly, fashion is as old as humans and will continue to be one of the most important areas of humans and maybe even robots. Certainly, design and fashion, it's something that might also apply to the way, driverless cars might be, or the robot that brings us the coffee and so on can actually, be. So there is a futuristic aspect of fashion, but now jokes aside, certainly technology has deeply revolutionized fashion. But at the same time, fashion is also finding back itself in the tradition. It's actually fashionable to have Dior using, of course, through collaboration, batik textile from some of the best Indonesian makers, original batik. And that all this intersection between materials, national origin, collaborations, it's something that we are seeing more and more. We see fashion entering hotels, food chains, gadgets, gift, chocolate in some way. Armani collaborating with Venki. This is a great example. And these are really interesting development, I would say. So we can see development branch off merchandising. We can see development in the contract. We can see development in the way rights are bundled to protect, in the new development, in the refashioning old fashion to make it, more appealing. So vintage with a twist. This is an area that will continue to grow, and just because it's part of the human creativity and will continue as long as we human continue to create.
I agree. I also think that insofar as fashion law specifically is concerned, over the next few years, this area of study, research, and practice will be consolidated further. So I anticipate that there might be a progression, not dissimilar to the one that we've had in other areas that are somewhat similar. I'm thinking, for example, of entertainment law. Today, this is a very well-developed area of the law. There are also some specific regulations, case law, etc. And I expect the same to be happening also for fashion and on a more global scale than what is the case at the moment. So it is an area that I think will be of greater and greater importance as we go forward, because as Irene pointed out, it is an all-encompassing type of field. It is not just about the garments that we have, it is about culture, it is about our identity, it is about our heritage, as well as more serious aspects such as conditions of laborers, the type of communication that is okay to have and not okay, and so on.
Thank you very much. What I can say is that I look forward to a second edition of the handbook. I would be happy to read the second edition and perhaps even contribute to it. Thank you, Eleonora and Irene, for joining me today and for this inspiring conversation. It was an honor to have you on our podcast.
It was our honor, and thank you, Anka, and the WIPO Knowledge Center for the kind invitation and the interest in our book and in this very important area of law.
Indeed. Thank you so much for having us. It's been an honor on our side. Thanks a lot.
Thank you, and we hope to have you again soon, maybe for the second edition. I hope you enjoyed my conversation with Irene and Eleonora. Their handbook will be available for purchase on the Oxford University Press website on the 27th February of this year. To find out more about Eleonora and Irene's next projects, make sure to follow them on LinkedIn. More information about this handbook and other IP works in our collection can be found via the WIPO Knowledge Center. Thank you for listening to this episode of Page Points. Until next time.